Everybody, welcome back for another video. Today I have Seth Meyer, a business and construction attorney here in the New York City area. Seth, welcome, man. Thanks
Thanks,
for
Jerry,
coming
man.
on.
I've been following you for God knows how long, and you are probably the number one guy who's hitting on the construction content. So it's really an honor to be here with you today. Thank you.
Thank you, man. Awesome. I know we connected probably well over a year ago, maybe
Yeah,
almost 2 years ago, and we've been sending messages. So we finally get to jump on a video call. But construction law, especially in and around the major cities, is obviously always certainly a major topic. And having a good lawyer on your side is part of having a successful business, in my opinion. So I want to quickly talk about the five topics we're going to talk about in this video. We're going to talk about payment issues in construction contracts, which are common. We're going to talk about the common payment disputes and when to lien. We're going to talk about scope creep. At what point you need to get a lawyer involved. If you're constantly being told to do what you feel is scope creep or change orders, right? And the GC or the owner is refusing to pay, at what point do you bring a lawyer in? And then we're going to talk about utilization plans, how to get firms certified to be a minority company. And then we're going to dive a little bit deeper into that on how to keep your certification as well. We're going to talk about compliance with changing payroll obligations. For the sake of you being a lawyer here in the New York State area, I know you had mentioned every state is got its own challenges. So for this video, we're going to talk about New York State. And then we're going to talk about legal considerations in construction contracts. We're going to talk about key clauses that protect you in your contracts, and also the role of mediation and arbitration in resolving disputes. So we have a lot to cover. I'm going to try to keep this around 30 minutes or so. So Seth, let's start diving into the first topic, payment issues in construction contracts. In your opinion, or in your field, obviously, what are the common payment disputes you've been seeing? And then we'll dive into the next segment.
sure. So, Jerry, number one issue, contractors, subcontractors, anyone in the chain of construction is dealing with today is getting paid. And every problem, every issue starts and ends with money. Because if you get paid, you can pay your lower tier folks. You can pay your unions. You can pay your material suppliers. Without that, everybody starts complaining, starts raising issues, starts making demands. You get letters from the collections folks. You get threats of being liened. You get threats of bond claims if applicable. You get the possibility for a really bad day. And depending on the type of project and depending on the location, you could be looking at liquidated damages. You could be looking at audit fees. You could be looking at all sorts of problems that are only caused by one person and one person only, Benjamin Franklin and his inability to get into your pocket.
That's awesome.
Yeah.
Well, it's a great analogy. So, I mean, common payment disputes. I mean, are there some examples that you can kind of throw at us that maybe you've seen lately?
Sure.
Without
So,
getting too confidential, let me say.
so public and private are both have unique concerns, but they all kind of stem from the same thing, is getting paid for work on time. Every construction contract, for the most part, will tell you you have to get your requisition in by X date, and you're going to get paid 30 to 45 days later. The problems we see is what happens when that payment is delayed, whether a municipality hasn't released the funds, a private owner, private GC hasn't gotten paid off their loan, or any other reason. Those all cause significant issues. We have contractors who've done change order work pre-COVID that still hasn't been paid. And you're asking a contractor to essentially fund a job, which they're in the worst position to do it because they're the trickle down to the trickle down. And that causes significant issues. We have issues where parties dispute whether back charges are applicable, whether the work is actually covered under this contract, or is it change order work? Is it contract work? Is it work that you should have been doing anyway? And it's not done either to the owner or to the GC specifications, and they don't want to pay you. Or they took away part of your scope because they don't think the project is moving fast enough. Or they, or there's any other reason why money's just not coming into your pocket, whether not having it or not wanting to give it. And that causes all sorts of issues. And that really forces a contractor, either a GC or a sub, to consider, how do I get this money? And you really, that's going to be the biggest business decision a contractor can make on the job. Well, do I send a letter? Hey, where's my money? How long do I let it go? Do I think about leaning the job? Every state has requirements of how long you can lien. For example, very, very broadly, on a private job, in New York, you have 8 months from your last work. In New Jersey, you have 90 days. So you really have to be thinking about these decisions as they're in real time, because otherwise you're going to be a step behind and you may have lost some of your leverage.
Yeah. Yeah, I mean, cash flow is probably one of the top 3 topics I always speak about. And I've had several of these videos just prior to you about cash flow specialists and financial lenders. And, it's so difficult to really understand how much cost to borrow money you need prior to a bid, because there's so much relying on, if you're a sub, there's so much relying on a GC and their scheduling. And I'll be honest, most GCs are messed up themselves, and they don't really understand how to plan out projects as well. So I'm hearing horror stories, even with some of my clients that I have now, where they're 90 days out, they're 120 days out, they're trying to get certain projects started. They have a whole list of change orders that, and we'll talk about this a little further on. They have a whole list of change orders that they feel that they need to be getting paid for. The GC doesn't agree because he or they think that the owner is not going to pay them, the GC. So it just becomes, it gets really messy. And I don't care how well you're planning out your projects. There's so many different people involved in each of this decision making that all it takes is that 1 or 2 people that don't agree with the predecessors or the successors of that decision making, where it just throws everything off. So you're talking about common payment disputes. At what point does a subcontractor say, you know what, enough is enough, I'm going to file for a lien? Because here's another thing too, is that this has been a big topic in my 20 plus years, and a lot of contractors are scared to file a lien for good reasons, because they don't want to burn a bridge with a GC who's feeding them 25-30% of their work every single year. So I understand where they're coming from, but at what point is enough? And at what point do you cut your ties with that GC and you file a lien? What are your thoughts on that?
A lien doesn't have to be the end all be all. And we've seen a couple of situations. We've seen the situation that you're dealing with, where if I lien the job, I'm going to lose that relationship. But we've also seen subs communicate with their GCs ahead of time. Hey, we haven't been paid. My rights almost expire, and then I can't get money. Then I lose this piece of leverage. And the GC will come back and say, hey, sub, I haven't been paid either in 6 months. So it could be to the GC and the sub's benefit to lien. So I had a sub who did a good amount of work, and they hadn't been paid or communicated with in 6+ months. Their lien window almost expired. We got that lien in. It noticed the GC and it noticed the owner. And then the owner comes out of nowhere and says, why are these issues? And the GC goes to the owner and says, you haven't paid me, so I can't pay these guys. And it opens up the conversation. So yeah, a lien stinks. It's a cloud on title. And you hired a GC, and now you have 2 brothers painting coming on and filing a lien for $100,000. The owner doesn't know who they are. Now you have the owner's lender saying, why is someone clouding title? Why is someone saying that they may foreclose on this project? And it really starts that conversation ahead. Says, hey, wow, we really need to do something here. Maybe our policies and procedures aren't right. Or maybe we're sleeping on this sub because we think they're not going to do anything. They're the guy, it's get along Charlie. Charlie's always been here to make sure the project goes right. But Charlie's got to get paid. Charlie's got to feed his family, and he's got to pay his workers, because then they're going to make a stink. And a lien is very powerful. And we've seen great success. And here's another thing. We had done work for a a material provider had done great work for a GC. The GC went out of business, filed for bankruptcy. So what's the sub going to do? Are they going to eat that? No. They leaned the job. The owner got involved and said, okay, I have to pay this sub because they can make life very difficult for me. And now we're going to have to fight this for what? They delivered the material. 100 boxes of nails were delivered to the site. No dispute. They got to get paid for their nails. So if you by leaning, you preserve your rights and you live to fight another day. Maybe the relationship is strained. Maybe they don't work together again. But at the end of the day, we have to see how do we protect our client and how do we get that money in-house so they can live to fight another day.
Yeah, and communication is critical, like you said. I mean, I would probably, and tell me if you disagree, but I would put it in writing multiple times, like 3 times. Say, hey, listen, this is where things are going right now. If I don't get paid, just picking up the phone all the time. So at some point, you got to put it in writing to have that backup. But can I ask you something? So if a sub files for a lien with a GC, right, and especially in the public world where being bondable is really big. How does that affect the bonding capacity of a GC if they get liens filed against them, or does that have any impact? I mean, what are your thoughts on that?
So it's a really interesting question because public leaning is very different than private. When you lean on the private side, you're leaning on a piece of property. When you're leaning on the public side, and specifically in New York, you're leaning on the project funds. Basically, the DOT set aside $3 million for this project. Subcontractor says, I'm owed $500K. They attach their lien to that money itself and say, you can't let go of that $500K until I'm paid. Now, what owners GCs on projects will do is they will bond that lien. So what they can do is say, great, that subcontractor bond lien the job, they're entitled to do it. As the owner, I can bond that lien. What it says is, we could take the lien away, and this company, the surety, is going to guarantee that $500K. It's a separate product aside from a payment bond or performance bond, which is another useful tool for a sub to use against the GC. And if you're a GC, to make your subs have bonds, it's very strong to ensure that your sub is maintaining its obligations.
Yeah. Wow. That's
yeah. I mean, if a GC, most public owners will require their GCs to have bonds, payment and performance bonds, to make sure the job gets done. And if it doesn't get done, the municipality has recourse against somebody. And we're seeing more and more that general contractors are requiring their subcontractors to have payment and performance bonds. And it's sometimes used to the GC's advantage that if a sub isn't doing a particular work the way that the GC likes, they're going to say, well, if you don't do this, or you don't fix that, or you don't come here, we're going to call your bonding company. We're going to make a claim that you're not performing. So it can be used as a sword as much of a shield. So
that's a relationship you want to keep solid with your bonding company. Sorry, go ahead.
Bonding company, bonding company is your license to do public work.
Yeah.
It's exactly. Being able to do the work is great. Being able to comply with obligations is fantastic. But if you don't have a bond, none of that matters, because the public owners want to make sure that you can finish the job, and if you can't, someone else will. And if you're certified, and it's also a badge of honor for a contractor. If they have a bond, your word is your bond. No, your bond is your bond. And if you have that bond, it says, I have been through the ringer. And that ringer, I have come out, and I am good. I am good to do this work. I have a track record, and I will bring you project success.
I have a client right now, and and we have aggressive growth plans. And I said, you gotta pick up your bonding capacity, because when you go and you start bidding with these with these larger GCs, for you to be able to tell them that you're bondable to X amount of dollars, I mean, that is huge. That's
Mhm.
huge. And
Yep,
and and you just kind of helped me solidify that.
right, and then, to what you're talking about on the payroll, the dollars in, dollars out cash flow, you have to make sure that you can collateralize that bond.
Yeah.
So as you're looking to grow prospectively with, oh, we're going to take on bigger jobs, you have to make sure your reserves are there to take on that work, because many bonding companies won't let you take out an unsecured bond. They want to make sure that you have real property, stocks, bonds, something else behind that bond in the case of a non-performance.
Yeah.
So it's as you grow, it's growing your bonding also means growing your reserve.
Wow. That's great. Great point, Seth. And that's great. I want to start moving on to the next topic, but we kind of already beat it up a little bit. But let's kind of get into the next topic of scope creep and change order, and possibly you can tell me one or two some examples you've seen of at what point does a subcontractor or even a GC to an owner
Mhm.
get a lawyer involved, to an attorney involved, to say, hey, I need help. I need help because I'm not getting paid. I'm not getting paid. I'm doing all this work there. Maybe they're threatening that they're going to throw me off the job unless I keep doing work that I know
Mhm.
is not part of our contract. So maybe you can expand on that a little bit more.
Sure. So I don't want to jump to our last topic first, but it also hits upon here. What the contract says matters a lot.
Yeah.
And who you help negotiate that contract with matters a lot. Because if you're just looking at the amount I'm going to get paid and when I get paid, game over. You've already lost. You have to know this contract inside and out, like it is your Bible, your guiding light on a job. And you want to get your attorney in there early. You want your attorney in there saying, hey, these are things we can change, these are things we can change. Change orders are a very important area to know, understand, and how to use it to your advantage. So if a sub is saying, this isn't part of my contract, the GC says, yes, it is. No, it's not. Okay, so what's our provision? What does the contract say? Contract says GC can tell you to do this work. You could do it under protest. You could do it on dispute. This way, you're backstopping yourself, and you get your lawyer in there early and often to help you craft those letters to the GC, to help you outline your timeframes. Oh, we'll see a lot of contracts. You have to let us know within 72 hours whether this is a change or this is a delay or this is something else. At the first blush, I'm getting in there if I see this contract before it's signed, and I'm jumping up those provisions. How are you going to know today that the plumber not coming to work means you have a change condition? We want to build that out so you can let that grow. So you want to get your lawyer in there early so he could counsel you on how to respond, how to position yourself, and how to document up the chain. So if there's an issue later on, you're fully protected.
Right. And again, this goes back to what we talked about before. This is about proper communication as well.
Sure.
It's communicating, putting this stuff in writing as much as
Hmm.
possible. And you don't necessarily need to get the lawyer to start writing these letters to a GC or to an owner right away. You could also call upon a lawyer to get your own personal legal counsel on how to approach it on the back end of the
Sure.
deal as well. Because again, I know what people are saying right now. Yeah, I'm gonna keep having my lawyer write these letters, and I'm going to be biting the hand that feeds me, right? You're not biting the hand that you feed that feeds you if you're communicating properly. But yeah, I mean, at some point, if that hand that feeds you is giving you 20% of your work, but yet they're refusing to pay you, and you're constantly waiting 6 months to get paid, and you're doing all this free work, and you're not making the
Hmm.
profits, you're not getting the cash flow. At some point, you got to cut ties with this GC as well.
So,
So
Jerry, I'll tell you, you hit on something great. The relationship, right? The lawyer, a good construction lawyer, for the most part, is in the background because I went to law
that's
school.
good.
If I try to use a hammer, I'm gonna hurt myself and 10 people around me. It's the same applies to dealing with construction relationships. I can help coach a client on what to say. I could even help write the letters, but unless they've gone legal first, I try to say, guys, keep the lawyers out of it. Your best your best bet with a lawyer is to be there guiding you, helping you. Keep those lines of communications open.
Consulting, advising.
It's consulting, it's advice, but it's also positioning for the worst case scenario, right? Because in 3 years, if you're in court and a judge is saying, "Hey, where's your notice?" "Oh, me and Paul talked about it on the side. We were gonna, we were texting. We were gonna make it work." Judge is gonna say, "That's great. What does that do for me?" "Oh, but judge, yeah, we sent the letter. We sent the letter as required by the contract. We did it." Now it shows the judge, one, they read their contract, two, they know what they're doing, and three, they made sure to preserve their rights. No one needs to know behind the scenes that the lawyer was helping them. No one needs to know that the lawyer was involved all the way through. So if it goes nuclear and it goes legal, you have an attorney from the other side coming in and they're trying to tell you this, that, and the other thing. You were there from day one helping your client. So you know what it was. So you have the institutional knowledge and the legal knowledge, and you put yourself in position to win.
Now, I want to bring up something else with this particular topic that I speak about all the time, and to me, it's an extremely hot topic, and it's something that if contractors were to get more into a habit of, their projects will be a lot more successful, and that is a proper project kickoff from estimate to project start. And the reason why I say that is that a good estimator is going to be able to present the project. Personally, when I was estimating, I mean, I was able to understand if that job was going to have a lot of change orders.
Sure.
You could tell by the project plans, the specifications, the RFIs that were sent in. You could tell by just your experience of knowing the logistics and how the plans are laid out and just the scope of work and within a project, right? If you're doing a lot of underground work, you know that there might be a lot of change orders if the borings stink or if the borings are spread out too far apart, especially if you have rock socket or if you have rock items within a project, right? So a good estimator with a good project kickoff will be able to set up the project management team really well from the beginning. And they'll be able to communicate, and a good surveyor would also be able to communicate, hey, these are the problems that you're probably going to have, and these are where your change orders are probably going to arrive from or going to derive from, let me say. So at that point, you can start the communication well in advance from even having to get a lawyer involved as well. So again, it starts with a good project kickoff, really getting going with a good project plan from the beginning, and understanding your budgets, understanding where the busts may have been happening, or where the bust may happen, for example, right? So in addition to the law, to the lawyer guidance and consulting throughout the project as well. If you got anything else to add me with this topic, I'll move to the next. Go ahead.
Yeah, just very quickly, you hit on it 1000%. Your estimator and your project team need to be communicating on change orders. How do we get the change orders in? When are they entertained? How are they entertained? What do we do if there's a delay because now we have borings that are not done properly? Now we have to bring someone in who wasn't supposed to be there to redo the work. How do we account for that in our contract, in our bid? And when these events happen, what's our playbook? Like there has to be someone on the estimating side talking with the project people on our bid book and how are we going to get that information up the chain so we're protected if we win this, when we win this job, and then we're not stuck funding this job.
Right. Just really quickly before we move to the next, I was talking to, and it's one of the top inspectors of a $1 billion+ project. I'm going to leave all names out and things of that nature. And he had told me that the GC, the joint venture, put like $150 million worth of change orders in a big package and delivered it at the end of the job. And long story short, the documentation sucked. They waited way too late to submit it because you got to get change orders in right away. And the judge pretty much threw it all out.
Yeah.
And the GC here is thinking that they may get 100 million, 120, in hopes of the full 150 million, and got nothing. So it's really, really important to document and have good legal advice on your side as you're continuing through these larger projects, especially if you're a smaller contractor and you really have an aggressive growth agenda, for example.
And
So-
another, very quickly, something that's super helpful to our clients is throw me on an email. Just put me as a CC. Once they see at lawfirm.com, they're going to be like, okay, maybe we have to be a little more cautious here because
it's a
their
good one.
lawyer's not active, but we know he exists, and he knows if something doesn't smell right, he's going to peek his head up in the moment.
That's awesome.
And it's like a business who puts their address at the Empire State Building because they bought they got a PO box. Oh, we have this whole law firm. Watch out.
That's a small tip that will have a huge impact. That's awesome. So next topic, utilization plans for certified firms. So this is basically if probably more for the public works sector, you want to become certified as a minority company, or DBE, WB, whatever it may be, SVE. What is your role in helping contractors get certified and to stay certified as well?
So the public entities have done a great job expanding participation by minorities, women, disadvantaged groups, service veterans, and a couple of other entities entitled to certification now. And it's great. It's great for upward mobility, bringing up the next generation of contractors. But it's rife with landmines, from getting that initial application in, to the interview, to building your resume, your projects completed. A lawyer is great early. If there's one takeaway today, it's get your lawyer involved early. So we'll work with firms that are considering going for certification, and we'll help get their documents in order. We'll help get their resumes in order. Basically, what do I do for the company? And why am I a legitimate, certifiable company? And getting them ready for their interviews, getting them ready to show that we are leaders, we are owners, we are growing, and we need the certification to take the next step. And we work hand in hand with their operationals folks, people like companies like Pro-Accel that basically say, hey, we're going to expand you out, but we need to make sure we have the right leadership in place. And on the certification front is that leadership has to come from a certifiable entity. You have to own, generally speaking, at least 51% of your company. You want to own more. You have to be involved in big decision making. You have to be the one making the most money. You have to really be there as the front, center, and back of your construction company to make sure you get certified. And then once you get certified, it's keeping that certification. So hurdle number one is working with the certifying agencies to become certified. Hurdle number two is keeping it, right? Because once you're certified, you have access to a fantastic pool of opportunities, big contracts, small contracts. Here's a pro tip for Pro-Accel. Make sure your certifications line up with your NICE code. Basically, it's the codes of work that you're entitled to do. Tax records and whatnot. So you can apply
Insurance.
It's everywhere.
Because I hear a lot of stories about that. Go ahead.
Exactly. So, when you're getting certified and you're bringing these opportunities to your company, make sure you can handle them. Make sure you have the growth plan in place. Everything you're talking about. We've seen private companies get into public work, and they had to staff up. It's not public contracting is as much as it is a back office job as it is a front office job, because you have to have that certified payroll in. You have to have that bonding capacity. You have to have the right insurance. You have to have the right staff. You have to have the right project leadership. And if you don't have the cash in the bank to pay for all that stuff, we need to make sure you're positioned there as well. It's a whole different ballgame on the public side. And that's a great opportunity for success and for failure. So we want to make sure that those subs and those GCs who are getting certified are really ready to take that next step.
That's great. No, that's awesome. And like how you said, becoming a minority certified company just opens up a massive door of opportunity for you, especially if you're in the public works sector. So,
Yeah.
I love these topics because one consistently rolls into the next, and now unless you got something else to add to that, I would like to pick up on our fourth topic, compliance with changing payroll obligations.
Sure.
All right, so you had mentioned that each state is different, obviously. So for the sake of this video, since you're a New York lawyer, we're going to speak about New York, unless you know anything about any other state. I know GCs are liable to sub payroll obligations, which is one of the subtopics that you spoke about prior to us getting onto this video. So if you want to expand on that as well, and what contractors really need to understand about this payroll obligations.
Sure. So basically, the way I like to look at it is if a subcontractor is hiring a worker, the entire project is hiring that worker. So the subcontractor has first line obligations to pay the worker. The owners of the subcontractor have the obligation to pay that worker. If that worker isn't paid, everyone up the chain is liable, from the GC to if they're a sub to the ones who brought them on. So really, we're starting to see, and this is public and private. So we're starting to see a lot of our private GCs asking subcontractors for payroll records, for reporting records, to make sure every dollar is further accounted for, because ultimately everyone can potentially be liable for not making payroll obligations. And that opens it up to punitive damages, liquidated damages. Lots of scary numbers come out to play when you don't pay workers.
So I got a question, and this kind of goes into this topic and one of the previous topics. If a subcontractor has to perform work and they don't have enough labor and they bring on a sub to themselves, right? What should they understand about that? Should they, obviously they should have their own subcontract in place, right? Because if the sub brings on someone and they get hurt on the job, for example, or like how you're saying, when they bring on someone of their own payroll, I mean, how can you expand on something like that, for a sub to bring in their own sub?
Sure. So one of the biggest issues, number two, other than getting paid, getting Benjamin Franklin into your pocket, is indemnification. It's a scary word. It touches on insurance. It touches upon contracts. It touches upon injured workers. What we want to make sure, and when we work in consultation with the insurance providers, is, are we protected in the event of a labor law claim? Are we protected in the event that a worker gets hurt? Because New York is a little bit different than some other states, where if a worker gets hurt, they generally can't sue their employer because they have workers' compensation benefits. But the injured worker can sue the higher tier sub, the GC, and the owner. So we want to make sure, as that subcontractor who's bringing on the sub, that that subcontractor is protecting everyone up the chain. Because sometimes it's a house of cards. If one contractor doesn't have proper indemnity, everybody in the chain loses insurance coverage. And that can be a death knell, because now you have the GC, the owner, saying, why did I lose coverage on this claim? Because subcontractor, you brought on another sub who didn't have the right coverage and you didn't have the right contract. So you have to make sure that if you're a subcontractor or a GC or anyone bringing on labor, you have proper indemnifications, you have proper risk transfer, proper risk sharing, to make sure that you're not the one holding the bag if there's a workplace injury.
Such an important part, such an important answer, because I've been hearing more and more stories of people just bringing on subs to their, and the GCs aren't even aware of it because they don't know who's who, and they don't have contracts, they don't have anything.
Sure. And I know we spent a lot of time talking about the subcontractors. General contractors have to make sure that their risk and compliance departments are staffed up. We have in our contracts from GCs down that if a sub brings on a sub, we know about it right away or they're not allowed on site. And that second tier sub has an obligation to maintain the insurance, same insurance requirements that the sub is required to keep. So if a sub has to have a $5 million policy, the sub has to have a $5 million policy. And we're counseling our clients to beef up compliance, to make sure that insurance is protected, that the risk transfer is as it should be. Otherwise, a project in the green will hit the red very fast.
Great. That's awesome points, man. I really appreciate that because, again, it's just a topic that I've been hearing more and more about. So,
And then, we're going to hit on contracts next. One of the strongest tools we like to put in our contracts, and again, every job is a little different, is what can the upstream contractor do if a claim like this happens? There's some provisions that say we can hold money back. A sub isn't getting paid until this lawsuit is resolved. And that could be a 6 or 7 figure sum. And what's the subcontractor going to say? Well, I'm entitled to this money because I did this work. And you're going to say, correct. But you also have a potential $1 million claim that you caused by not having proper insurances up the chain to protect everybody, to protect yourself, to protect us from your sub. So we always have to be mindful of that and finding ways to protect ourselves when things go wrong.
legal considerations in construction contracts. We got
Mhm.
kind of two subcategories here, right? So we have key clauses to protect you, which is kind of what
Sure.
you're talking about. And then what's the role of mediation and arbitration and resolving disputes? So what are the key clauses to protect a contract? And I guess you could talk for both subcontractors and
Yeah.
GCs.
So the big thing to know about contracts, there's two kinds of contracts. One, there's the contracts you can't negotiate, and there are the contracts that you can negotiate. If Department of Public Works is saying, here's our contract, follow our contract, you're not going to start marking that up. You can try. They're going to say, oh, look at that. The next lowest bidder is suddenly became available. So in those situations, we like to counsel our clients on, these are the details you need to know. You can't change it, but let's navigate. So some of the things that we've hit on before: notice, change orders, delays, disputes, indemnification, manpower, scheduling, right? So we've seen some contracts where the GC has the right to direct the sub to provide more labor without a change order. Hey, you have 5 guys on site. We need 10. This is your cost. So where are these hidden landmines, and how do we take them out of the shadows so the subcontractor or the GC can say, we need to plan around this? Another big thing we see, private and public, are liquidated damages. If you don't hit your scheduled milestones, we can charge you $1,000 a day. Well, no, I don't want to be charged $1,000 a day.
Right.
There was a delay here. How do I get how do I protect my delay rights? So on the public side, in some private contracts, you're not going to be able to touch a thing. You just have to know where the devils are, where the landmines are, and an attorney and you're working with your project folks can help you identify that. Because if you go in early knowing what the problems are, you can solve the problems before they get bigger. On most private contracts, you can negotiate with the GC, you can negotiate with the owner, you can negotiate with the sub. At the very least, I try to get them better provisions on notice. You have to tell us if your project will be delayed within 72 hours. 72 hours happened on Friday afternoon. It's Monday morning. I blew my window. How am I supposed to know that this is going to cost me $10 million? No, let's get you some more time so you can talk it out. To combat this, I've seen some subs and GCs send notices every Friday. Our project was delayed because we missed the elevator because the bricklayer got in there before me, and I don't know what the impact is, but we anticipate it being substantial. Lunch was cold and our workers weren't happy. This could be a significant delay to the project. We don't know the impact yet, but be on notice. Most contractors aren't going to do that. So it's giving them more time to flesh out problems. Working change order language that's more favorable. Well, if I can't find an agreement, how do I get paid? Do I get paid under some determined by the architect? Do I get it on time and material? What's better for my trade? How can I make the situation better for me? Hidden damages clauses. You'll get something that's called consequential damages. Okay, there was a breach in the contract. Because I couldn't do my work because of the preceding contractor, I had an impact. A lot of times you get more time. Sometimes they're going to say, whoa, 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 because you couldn't do your work, we lost profit on another job. Are you really going to be on the hook for someone else's other job? We're mindful of those provisions, and we try to work them in or out depending on where we are.
I just want to expand on the delays.
Mhm.
That was a big thing when I was running my own jobs out in the field, right? And that was one of the main things that I had drilled into my head when I just started to run my own work is
Mhm.
I hated doing schedules. I always try to outsource that to whomever else, but I needed to be a part of the scheduling process,
Mhm.
right? And I always made sure that one in my regular schedules, my monthly schedules that we had to submit part of our contract, and also my look ahead schedules that I also sent to the inspectors and the owners reps. I I made sure they understood that a change order was delaying the project or something like, for example, them not getting a submittal back to me in a
Yep.
certain amount of time because the spec allocates a certain amount of time that the inspector has to get a
Mhm.
submittal back. Sometimes it goes above and beyond that.
Sure.
So I would always make sure that my schedules reflected that delay because guess what happens? Like how you said, liquidated damages. And when you're in a city like New York City, liquidated damages could be 10, 15, 20, thirty
Mhm.
thousand dollars a day. I remember when I was out in lane closures, and this is kind of a little bit separate, but when I was out in lane closures, for every 15 minutes over a lane closure hour that I had to pick up a lane closure, it was like $1,500 for every 15 minutes. Sometimes
Sure.
$5,000. On one job, it was $5,000. So it's really important to document delays, whether it be a submittal delay or a
Mhm.
submittal revision delay or just a delay caused by a change order. So
Yeah, you gotta. It's a must.
yeah. So the final subtopic of this last topic is the role of mediation and arbitration in resolving disputes. You want to expand on that?
So dispute provisions happen, and disputes happen when we can't agree. We're owed money. They don't think we're going to get the money. There's a delay. They say it's not compensable. We think it's compensable. They want liquidated damages. We don't think we have to pay. Now what? We've tried to work it out directly. We tried to handle it as business folks, but it just didn't work. And now we have to go legal to a formal dispute resolution. Now we're seeing two main types of dispute resolution. We think, okay, we're going to run into the courthouse, we're going to tell a judge what went wrong, and we're going to get paid. That's one way. The other way is we're starting to see a lot more of it is arbitration. So what's arbitration? Arbitration is a private dispute mechanism. Basically, instead of going to court, guy or gal in a black robe telling us you're right, you're wrong, a jury, we're going before somebody who we hope is experienced in construction. We hope that we're going before someone who's been an attorney on construction projects, that they know the ups, they know the downs, they know what could happen. That's truly an expert in construction. And they will hear the dispute. The parties will exchange evidence. They will have witnesses come up. You'll have experts. And from there, this attorney, sometimes it's not an attorney, this person will determine the resolution. The pros of arbitration are it can be quicker. A court process can be 3 to 5 years. And the judge who's handling your case may be dealing with a dog bite, maybe dealing with a foreclosure, and then he's dealing or she is dealing with construction project gone wrong. They may not be the most equipped to handle our specific construction issues. The other benefit is the law is more loosely applied. What that means is you go into court, if you didn't comply with every single line of the contract, there's a good chance as a sub, your case may be thrown out. If you didn't submit your change order when the moon was at its highest peak in pigeon blood, and it was written on a scroll from the 16th century, a judge in New York will throw you out. In arbitration, you may have a better shot at getting your money. Usually, before arbitration, they make the contracts now are making the parties go to mediation. Mediation is much more informal. Similarly, you're going to go to, hopefully, a construction professional who knows the industry. They'll sit down with both sides, the sub, the GC, or the owner, and say, what happened here? Well, we had these delays. We had these impacts. This change order hasn't been paid. And he makes a recommendation. He could try to discuss the pros and cons of each side's case while also saying, hey, this goes to court or this goes to arbitration. You may have a problem. So it's a way to try to resolve things before people spend a ton of money and a ton of time in arbitration or in court. And it's really a nice opportunity for everyone to take a deep breath and say, okay, I have my professionals here. They've been telling me something for the last 6 months to a year. The other side's been saying something else. Now we have somebody who we can listen to, and they could say, okay, the other side is right here. We're right here. Let's try to come to something in the middle so we don't have to spend lawyers. We can spend that money on our professionals who can help our business grow in the future.
That's all. This video has been all gold, man. I hope growing contractors are going to watch this video multiple times because there's so much information here, and I mean I've said this many times on all my social media accounts as well. And if there's one business that's probably the most riskiest business in the world, it's got to be construction in the top three, right? I mean, there's so many moving parts in this business, you know, and there's so much to learn, and there's so many resources, like people like us, for example, where, you know, you can either learn the hard way and be reactive all the time, or learn the easier way by picking up the phone and asking for help and be proactive, you know. So unless you got something else, Seth, that you want to add anything else before we close up this video?
As I tell all my contractors, make sure you get your change order signed.
Every day. Every day.
day.
Well, your T&M sheets should be signed every day. Your
Yes.
T&M sheets, your time and your material sheets, if you don't know what that means. I was always taught you got to have them signed every day, and then as soon as you're done with that change order, you submit it right away.
Right away.
So,
Early and often. Don't let things linger. Talk to your professionals. We're here to help you, because the earlier you get us involved, the more we can do.
you're hearing that from the mouth of a lawyer. 14 years in the business, he knows what he's talking about. So, Seth, if people need legal advice from you in this area, you know, which states do you work with? One, and then two, how can people find you and contact you?
So I do a lot of work in New York, New Jersey, some work in Connecticut, public and private, material suppliers, contractors, GCs, and owners. You know, I do it all, so I've seen a lot of it. Where you can find me, I'm on LinkedIn. Wherever Jerry's posting, you can find me liking and commenting. Don't Google me.
Support.
Don't Google me, because my funny alter ego Seth Myers will pop up. You can always get me at Kaufman Dolowich. We're a great firm that helps a lot of the construction industry with construction issues, labor issues, contract issues, and workplace injury issues. So we're here for you. We're a friend of the trades. We're a friend of the GCs. We're a friend for everybody.
Awesome. Thanks, man. And I'm Jerry Aliberti, owner of Pro-Accel. If you're watching this video on YouTube, I encourage you to subscribe, like, and comment. Comment any questions that you may have for Seth, and I'll forward it to him. Go to my profile, go to my website. Under free resources, you can also find this video with a blog. And I'm on social media. I'm on Instagram. I'm on LinkedIn. All my accounts are under my YouTube profile account. Seth, thanks again for coming on board, man. Until the next time.
Thank you for having me. And just remember, this could be attorney advertising. Prior outcomes do not guarantee future results.
Wow, look at that. Awesome note to end on. Thanks, man.
Thanks for having me.